let us start a very important aspect of the information technology law, that is salient feature of the Information Technology Act 2000. So starting from the very beginning, as we know, the Information Technology Act has been divided into 13 chapters and the 4 schedule, whereas total 13 chapters has been divided into 92 sections. But now Section 91 and 92 has now been repealed, and therefore at present we have 90 sections and 2 schedule, because schedule 3 and schedule 4 has now been repealed. Now start with chapter 1 of the Information Technology Act, that is preliminary section, that start from section 1 to section 2. Section 1 that deals with the short title, extent, commencement and application of the Information Technology Act 2000. As we know, Information Technology Act is now is dependent over the ancestral model law of the United Nations, and therefore it is suggested and it is made an objective in the ancestral model law that while passing a law by any particular country or by any signatory nation, then they shall give a favorable consideration to the ancestral model law over the information technology. So what happened while while Indian Parliament passing Information Technology Act 2000, they have given a favorable consideration to the ancestral model law. But it not only dependent over the ancestral model law, rather we have incorporated many things to the under the Information Technology Act 2000. For example, we have incorporated crime, we have incorporated e-governance, so many things we have incorporated apart from the e-commerce. So let us come to the point, section number 1, that deals with the short title, extent and commencement. Its short title is the Information Technology Act 2000, and it extends to the whole of India, and it shall come into force on such and such date as the central government notified. And it is having a overriding effect. You must keep in mind the Information Technology Act is having a overriding effect. Come to the point number 2, that under Information Technology Act 2000, under section 2, there are various definition has been given under the code, and let us take some definition. For example, access has been defined, that what we call access. For example, if your friend is gaining access to your computer system or computer network, or just your friend ask your mobile, and if he enters without your permission into your gallery or into your WhatsApp chat or over your Facebook account from your phone, that means he had gained access to your computer, and thereby he has committed a cyber contravention as per section 43 of the Information Technology Act. Similarly, we have a definition of adversary, we have definition of affixing, we have definition of the asymmetric crypto system. Asymmetric crypto system is basically applicable to the digital signature, and in case of digital signature, asymmetric crypto system is applied where public key and private key is being generated by the certifying authority, and the person who is holder of the private key is basically the owner of the digital signature. Similarly, the term communication devices has been defined, the term computer sources has been defined, the term computer has been defined, the term cyber cafe has been defined, even the term data. Data means any raw material which represents the concept is being defined under section 2 of the Information Technology Act. Similarly, the term digital signature, electronic signature, and uh, key pairs, private key, public key, everything has been defined under section 2 of the Information Technology Act. So even if you are not finding out any solution from the Information Technology Act, then we will jump over the Indian Penal Code, where certain definition, certain term has been defined. Similarly, we will jump over the Indian Evidence Act, we will jump over the Bankers Books Evidence Act, because it was get amended by the Information Technology Act 2000. So that is why we will take into consideration these acts while interpreting the Information Technology law. And if we will not find any solution, then we will jump over the General Clauses Act. Now come to the point, chapter 2 of the Information Technology Act, that deals with the digital signature, electronic signature, and that is given under section 3 and section 3A of the Information Technology Act. The term digital signature has been defined under section 3, and the term electronic signature has been defined under section 3A. That we will discuss it later, that what we call the digital signature. Basically, the digital signature is dependent over the asymmetric crypto system, where the public key and private key is being generated, and the public is having the public key who can verify the signature issued by the holder of the signature, and the electronic signature is having a very wider connotation. Even the scan copy of your handwritten signature can be termed as electronic signature, or if you are sending the mail to your friend containing your name, your address, can be termed as your signature, or if you're sending a SMS by the mobile, that can be termed as a electronic signature, or if you are receiving a OTP over your phone for transferring the amount to the your friend. In such a situation, if you are just as soon as you are entering the OTP to the to the phone for transferring the amount, in such a situation it shall be considered, it shall be deemed that you have signed over the document, and therefore it is now having a legal sanctity. Come to the point, chapter 3 of the Information Technology Act, that has been incorporated not based on the ancestral model law, rather it was our need, ये हमारी एक ज़रूरत थी, इसलिए हमने जो है ई गवर्नेंस के चैप्टर को रखा, that start from section 4 to section 10A of the Information Technology Act. So what it basically deals, it deals with the legal recognition of electronic records. Let me give you an example. सपोज करिए कि आप जो है ट्रेन में जा रहे हैं और आपके पास एक सॉफ्ट कॉपी है आपके ट्रेन टिकट का, एंड व्हाट द टीटी आस्क यू द टिकट, इंस्टेड ऑफ शोइंग इट over the paper, you are showing a SMS issued by the railway to the TT. So it has a legal recognition, because section 4 says so. Section 4 says legal recognition of electronic records. सपोज करिए कि अगर ये लीगली रिकॉग्नाइज नहीं होता तो वो टीटी आपको बोलता कि नहीं, आप जो है ट्रेन से उतर जाइए और ये आपका टिकट वैलिड नहीं है. सिमिलरली इफ यू आर सेंडिंग अ मेल टू योर फ्रेंड, देन दैट इज हैविंग अ लीगल recognition, because section 4 recognizes it as a electronic record. Similarly, you are filing a document to the government agencies, that is having a legal recognition. So whatever the things are available in hard copy, if that thing is available in the soft copy, that is also legally recognized. For example, आप लोग जब गांव में रहते होंगे तो वहाँ पे देखा होगा कि खाता, खसरा, खतौनी जो है वो आपको अब सॉफ्ट कॉपी में अवेलेबल है. आपको अपनी ज़मीन की अगर कागजात देखने हैं, सो दैट इज़ इलेक्ट्रॉनिकली अवेलेबल ओवर द वेबसाइट ऑफ द गवर्नमेंट. फॉर एग्जांपल इन यूपी, दैट इज़ bhulekh.gov.in. there is a website called bhulekh.government.in. so that on that website you can get the information of your land record, because it has a legal recognition. Similarly, legal recognition of digital signature. The question is, even if the document is legally recognized, so without signature, how it can be authenticated? How without signature it can be legally recognized? So therefore, even the digital signature is now being legally recognized. Similarly, we have section 7, that is retention of electronic record. अब प्रॉब्लम ये आती है कि आपको अपना रिकॉर्ड जो है उसका रिटेंशन भी होना चाहिए. ऐसा थोड़ी है कि आपने उसको मेल में रखा और कल को मेल जो है डिलीट हो गया, देन हाउ वुड यू एबल टू शो दैट रिकॉर्ड दैट इट वाज लीगली रिकॉग्नाइज्ड? नो, यू कैन नॉट बी एबल टू शो दोज रिकॉर्ड्स अनलेस एंड अनटिल इट इज बीइंग रिटेन्ड इन द इलेक्ट्रॉनिक फॉर्म. तो उसको जो है इलेक्ट्रॉनिक फॉर्म में रिटेन करने का भी एक लीगल रिकॉग्निशन है. अगर आपने उसको किसी सीडी में बंद करके रखा हुआ है, या आपने उसको जो है किसी ऑनलाइन ड्राइव पे रखा हुआ है, जैसे गूगल ड्राइव है, वन ड्राइव है, और कुछ जो है ड्रॉप बॉक्स हैं, इस टाइप के कुछ जो है ऑनलाइन वेबसाइट्स जो हैं आपको ऑनलाइन स्टोरेज देते हैं, तो वहाँ पे आप अपने डॉक्यूमेंट्स को safely रख सकते हैं, and that has now been legally recognized by virtue of section 7 of the Information Technology Act. इसी तरीके से publication of official gazette in electronic form. So as per section 8 of the Information Technology Act, if a document, if a official gazette has been published in the electronic form, then that has same legal validity as it was published in the document form, as it was published in the paper form. तो जो भी ऑफिस का जो ऑफिशियल गैजेट आता है गवर्नमेंट ऑफ इंडिया का, अगर वो किसी भी मिनिस्ट्री की वेबसाइट पे आ जाता है तो उसको हम जो है ये मानेंगे कि इट इज़ हैविंग अ लीगल सैंक्टिटी बाय द गवर्नमेंट ऑफ इंडिया। अब प्रॉब्लम ये आती है कि विच डेट वुड बी कंसीडर्ड। हो सकता है कि आज वो डॉक्यूमेंट, वो ऑफिशियल गैजेट जो है आज की डेट में वो इन वेबसाइट पे आया और कल जाकर के वो क्या कहते हैं कि document form में आया। In such a situation, the date on which the gazette was first published, if it is published first in the electronic form, then that date shall be considered as the date of the publication of gazette in the electronic form. Now come to the point, validity of contract form through the electronic means, that section 10A. Now suppose there is person called A and other person called B. If they are making a contract, of course if they are making a contract, then definitely there would be a documentation, there would be some terms and condition between these two persons, and there would be signature of both persons, that what would be the consideration among us. So if a person is making a contract in electronic form, that is also legally valid. What does it mean? In case of electronic contract, what happen, you can send a mail to other party, and if other party replied with the counter mail, then that is basically offer and acceptance, and ultimately there will be promise and consideration, and now it will be converted into the contract, and it is only and only get possible through section 10A of the Information Technology Act, where it provided the validity of contracts formed through electronic means. For example, if you are going to purchase certain thing over the Amazon, over the Flipkart, Snapdeal, आप वहाँ से कोई भी चीज़ परचेस करते हैं और जैसे ही आप जो है आप क्लिक करते हैं आई एग्री, what does it mean? You are now agreeing with the terms and condition of the Amazon, you are agreeing with the terms and condition of the Flipkart, and therefore you are going to enter into the contract with the Flipkart, and thereby a standard form of contract is being formed between you and the company, and that has been a legal recognition by virtue of section 10A of the Information Technology Act. Now come to the point, electronic contract. That is given under chapter 4 of the Information Technology Act, that is start from section 11 to section 13 of the Information Technology Act, and therefore एज पर सेक्शन 11, दैट इज एट्रीब्यूशन ऑफ इलेक्ट्रॉनिक रिकॉर्ड्स। आप कैसे जो है इंफॉर्मेशन सेंड करेंगे, कैसे इंफॉर्मेशन रिसीव करेंगे, और कब कहा जाएगा कि ये इंफॉर्मेशन जो है रिसीव हो गई, ये इंफॉर्मेशन सेंड हो गई, ये एक्नॉलेजमेंट ऑफ कम्युनिकेशन हो गया, ये एक्नॉलेजमेंट ऑफ रिसिप्ट हो गया, दैट हैज़ बीन गिवन अंडर द सेक्शन 11, 12 एंड 13 ऑफ द इंफॉर्मेशन टेक्नोलॉजी एक्ट। कब बोलेंगे कि नाउ इट इज ऑफर, इट इज एक्सेप्टेंस, एंड देयरफॉर नाउ इट बिकम प्रॉमिस, एंड अल्टीमेटली इट बिकम अ कॉन्ट्रैक्ट। सो earlier it was being governed by the Contract Act, but now in case of electronic means it is being governed by section 11 to section 13 of the Information Technology Act, as well as it shall be read with section 10A of the Information Technology Act. सिमिलरली ई गवर्नेंस के केस में क्या होता है कि इफ़ यू आर गोइंग टू फाइल एन एप्लीकेशन बिफोर द गवर्नमेंट, इफ़ यू आर फाइलिंग द एप्लीकेशन थ्रू ऑनलाइन मोड, दैट इज आल्सो लीगली रिकॉग्नाइज्ड अंडर चैप्टर 3 ऑफ द ई गवर्नेंस ऑफ इंफॉर्मेशन टेक्नोलॉजी एक्ट 2000. फॉर एग्जांपल, you are filing an RTI in the online medium, so that is legally valid RTI application, and thereby you are getting the information through the ministry concern or through the department concern, because it is being directed to such department, and thereby you are getting the information. Or even if the government suppose giving you some direct benefit, then it can be it can only be possible through the chapter 3 of the Information Technology Act, that is e-governance. That chapter deals with the e-governance, and therefore government is directly giving you the benefit. Come to another important aspect of the Information Technology Act, that is chapter 6 of the Information Technology Act, that deals with the regulation of certifying authority, and that start from section 17 to section 34. देखिए होता क्या है कि ठीक है, आपने डॉक्यूमेंट को रिकॉग्नाइज कर दिया लीगली अंडर सेक्शन 4, आपने इलेक्ट्रॉनिक कॉन्ट्रैक्ट को रिकॉग्नाइज कर दिया अंडर सेक्शन 10A, आपने डिजिटल सिग्नेचर को रिकॉग्नाइज कर दिया, आपने इलेक्ट्रॉनिक सिग्नेचर को रिकॉग्नाइज कर दिया, बट हाउ इट वुड बी इफेक्टेड, आप इसको इम्प्लीमेंट कैसे करोगे? सो दैट इम्प्लीमेंटेशन इज गिवन अंडर चैप्टर 6 ऑफ द इंफॉर्मेशन टेक्नोलॉजी एक्ट, दैट इज रेगुलेशन ऑफ सर्टिफाइंग अथॉरिटी। होता क्या है कि आप डिजिटल सिग्नेचर को इशू करने के लिए एक सर्टिफाइंग अथॉरिटी का इस्टेब्लिशमेंट करते हैं, दैट इज इस्टेब्लिश अंडर द कंट्रोलर ऑफ द सर्टिफाइंग अथॉरिटी इस्टेब्लिश अंडर सेक्शन 17, ही इज बीइंग अपॉइंटेड अंडर सेक्शन 17 ऑफ द इंफॉर्मेशन टेक्नोलॉजी एक्ट। और कंट्रोलर फिर जो है सर्टिफाइंग अथॉरिटी को रिकॉग्नाइज करता है कि नाउ यू कैन इशू डिजिटल सिग्नेचर सर्टिफिकेट, एंड हिज पावर फंक्शन and the certifying authorities power function is given, and the license to issue has been the power to issue license has been given to the controller to issue digital signature certificates to the subscriber। अब प्रॉब्लम थोड़ा सा ये टेक्निकल हो गया। देखिए सबसे टॉप पे जो है वो कंट्रोलर होता है, उसके नीचे सर्टिफाइंग अथॉरिटी होता है, उसके नीचे जो है सब्सक्राइबर्स होते हैं, आम नागरिक, जनरल पब्लिक या कंपनी जो उस डिजिटल सिग्नेचर को यूज़ करते हैं। सर्टिफाइंग कंट्रोलर का क्या काम है? सर्टिफाइंग अथॉरिटीज़ को सर्टिफाई करना कि नाउ यू आर एलिजिबल टू इशू डिजिटल सिग्नेचर सर्टिफिकेट्स। और जब वो डिजिटल सिग्नेचर सर्टिफिकेट्स को इशू करते हैं तो उसके बाद जो है वो जो सब्सक्राइबर्स हैं वो नाउ दे आर बीइंग authenticated by the certifying authority to issue their digital signature to the general public, and the general public can verify the digital signature by the use of public key. So we have private key and public key infrastructure, and that is called asymmetric crypto system. So under section 6 we have many things, for example the surrender of license, suspension of license, power to delegate, and renewal of license. Many things has been given under section under chapter 6 of the Information Technology Act. Now come to the point chapter 7 that deals with the electronic signature certificate. So अब इलेक्ट्रॉनिक सिग्नेचर सर्टिफिकेट जो है वो इश्यू हो गया। नाउ सर्टिफाइंग अथॉरिटीज एज given under chapter 6 are issuing the electronic signature certificate to the person concerned, the subscriber, and they are also having authority to revoke the electronic signature certificate. They are also having authority to suspend the electronic signature certificate. They can issue notices to the subscriber. So that all thing would be done under chapter 7 starting from section 35 to section 39. Now come to the point chapter 8 of the Information Technology that deals with the duties of the subscriber। अब देखिए सब्सक्राइबर की क्या ड्यूटी है, वो कैसे अपने की पेयर को जनरेट करेगा, उसको कैसे कंट्रोल करेगा, वो डिजिटल सिग्नेचर सर्टिफिकेट को एक्सेप्ट कैसे करेगा, उसका कंट्रोल कैसे करेगा, ये सारी चीज़ें जो है वो सेक्शन 40 टू सेक्शन 42 में दी गई हैं अंडर इंफॉर्मेशन टेक्नोलॉजी एक्ट 2000। So these all are the duties of the subscriber, that how to take care, how to handle the key pair, that is public key and private key infrastructure. We have a very important chapter called chapter 9 of the Information Technology Act, and that deals with the cyber contravention under section 43 of the Information Technology Act, adjudication under section 46, and the penalties that start from section 43 to section 47 of the Information Technology Act. Cyber contravention is one of the important aspect of the Information Technology Act, although it is not given under your chapter, but we will under your syllabus, but we will study that what we call the cyber contravention. The term cyber contravention is not defined, but it is given under section 43 that what are those acts which can be termed as the cyber contravention. For example, if suppose someone getting access to your computer, that is cyber contravention. For example, if your friend getting access to your personal profile, your friend just taken your mobile. So these can be termed as the gaining access to your computer without permission. If someone getting access without permission, then it is called as cyber contravention. If he is gaining access with an intention to commit the crime, then it would be converted into cyber crime by virtue of section 66. So section 43 read with section 66 shall be converted into a crime. So cyber contravention is basically civil in nature, whereas cyber crime is basically a crime criminal in nature. So in case of violation of cyber contravention, or if there is violation of section 43, then there would be a compensation, there would be a penalty, there would be damages by way of compensation as per section 43 of the Information Technology Act. And similarly, someone is downloading the information, someone copying, if suppose someone getting access into your computer and copies a PDF file from your computer, then that can be termed as the cyber contravention. Similarly, if he damages the file, if he deletes the file, or even if he is denying access to a legally recognized person, if he is denying the lawful owner to gaining access to his computer, for example, A denying access to B, no, you cannot get access to your computer, then that is also a cyber contravention. Or if he is providing assistance to gain access, that is also a cyber contravention. चार्जेस सर्विसेज के, ठीक है, आपका कंप्यूटर है लेकिन आपको अपना कंप्यूटर लेने के लिए या अपने कंप्यूटर में एंट्री करने के लिए कुछ चार्जेस हमें देने पड़ेंगे, दैट इज आल्सो अ साइबर contravention. Or if he is destroys, deletes the information containing in the computer, that all can be termed as the cyber contravention. Or if he steals, conceals the information, that is also a cyber contravention by virtue of section 43 of the Information Technology Act, and he would be liable to pay damages by way of compensation. Similarly, we have section 46 where if any disputes is being arises, then adjudicating officer has been appointed under section 46 and he would adjudicate the matter, and his jurisdiction is to entertain the matter which is less than 5 crore rupees. If it is more than 5 crore rupees, then the jurisdiction would be vested in the appropriate court, competent court. So the jurisdiction would be vested in the competent court, and less than 5, if the matter is, the dispute is below 5 crore rupees, then the jurisdiction lie with the adjudicating officer. Now come to the point, chapter 9 of the Information Technology Act, that deals with the Appellate Tribunal. Earlier its name was Cyber Appellate Tribunal, but after passing of Finance Act 2017, I repeat, after passing of Finance Act 2017, now the term Cyber Appellate Tribunal has been substituted with the new term, that is Appellate Tribunal. The chapter 10 starts from section 48 to section 64 of the 48 to section 64 of the Information Technology Act. So tribunal as established under Telecom Regulatory Authority of India Act 1997, under that law, tribunal has been established. So now that tribunal is also acting as an appellate tribunal under section 48 of the Information Technology Act. So if any dispute arises, then it would be go to a tribunal which is established under the Telecom Regulatory Authority of India Act 1997 by virtue of Finance Act 2017. So the powers and function, their seating, benches, all are given starting from section 48 to section 64, and there is an appeal to High Court, what be the jurisdiction, whether civil court can entertain the matter, whether civil court, bar of civil court jurisdiction, all are given in the chapter 10 of the Information Technology Act, that is Appellate Tribunal. So you must keep in mind, earlier its name was Cyber Appellate Tribunal, but now by virtue of Finance Act 2017, its name is Appellate Tribunal. Come to the point, the offenses. That is one of the most important aspect of the Information Technology Act, and therefore we have incorporated. There are various offenses as defined under Information Technology Act 2000, starting from section 65 to section 78 of the Information Technology Act, and not only defining the crime, rather it providing the punishment. For example, The term hacking, not basically not hacking, rather it containing the ingredients of the hacking, is defined under section 65 of the Information Technology Act, and the computer related offenses is defined under section 66. I told you earlier that section 43 shall be read with section 66 if any person committing cyber contravention, and that contravention is with an intention to commit the crime, then definitely it would be converted into the cyber crime by virtue of section 66 of the Information Technology Act. So section 43 plus section 66 is equal to an offense. Section 43 per se is not an offense, rather it is simply a cyber contravention, and it is civil in nature, and therefore the person has to pay the damages by way of penalty. Whereas in case of section 66, the person has to undergo the imprisonment. Offensive messages as defined under section 66A, that has now been declared unconstitutional by the Supreme Court of India in the year 2013 by the in the judgment called Shreya Singhal versus Union of India. We will discuss it, we will discuss in detail later. Identity theft as defined under section 66, although identity theft is also defined under the Indian Penal Code, but here identity theft in case of through electronic means is also defined. For example, someone just getting access into your Facebook account, and thereby he is sending messages to other in name of yours, or someone made a false email account and thereby sending the email messages to your friend, then in such a situation it is called as identity theft. Violation of privacy is given under section 66A of information section 66E of the Information Technology Act. For example, someone is violating someone's privacy, someone capturing the photograph, naked photograph, that is also called the violation of privacy. Cyber terrorism, so when the offenses affecting the integrity, security of the nation, if it is against the country, then it is called the cyber terrorism. For example, someone getting access to into your computer, that is cyber contravention. If someone getting access with an intention to commit the crime, for example deleting and thereafter transferring that information to other, then that is called the cyber offenses, read with section 66. If suppose that person is getting access to the computer which belongs to the Ministry of Defense, the army, the police, then it would be converted into cyber terrorism. The same act of gaining access would be converted into cyber terrorism. Cyber obscenity is defined under section 66 and section 67A of the Information Technology Act. For example, clicking publishing a morphed photograph of a woman, that is cyber obscenity. Child pornography, that is defined under section 67, and the punishment has been given under section 67B of the Information Technology Act. Breach of confidentiality is given under section 72 of the Information Technology Act, and extraterritorial operation is given under section 75 of the Information Technology Act. So our act is having extraterritorial operation, and it has validity from article 245 clause 2 of the Indian Constitution, which says no law shall be deemed to be invalid only on the ground that it would have extraterritorial operation. So our Information Technology Act is having extraterritorial operation. It shall be read with section 75 shall be read with section 1 clause 2 of the Information Technology Act, and also shall be read with section 3 and 4 of the Indian Penal Code 1860. Thank you very much. I must consider that you have understood that what are the salient features of the Information Technology Act 2000. We will study chapter by chapter in detail in our next video and classes. Thank you.